Hi, everybody. Thank you for attending our webinar regarding Beyond Standard Sponsorship, and it's regarding the labor agreements. Next slide, please. Just very briefly who we are and what we do. Our company is No Borders Law Group and specifically MB Migration. We also have a number of divisions, employment, property and commercial. We started our migration practice in 1998 as a migration agency, and probably about 5-6 years ago we have become a migration law firm after the deregulation of the industry. Our mission is to offer services to our clients moving forward and achieving new life for our visa applicants and for businesses to support them to further expand their workforce in Australia. Next slide, please. Okay, key discussion today, and as I mentioned at the beginning, we will focus today on the employer-sponsored visa classes and nomination, labor agreement, DAMA, and different services. So understanding what is the labor agreement, why labor agreement exists, and when they are used, businesses best suited for labor agreements, and how labor agreements can support the workforce needs in your business. Next one. Okay, so I'm sure you are all familiar with the different streams under the employer-sponsored streams. And the main one is usually the temporary sponsorship, the 482, which has two different areas. One is the core skills and one is the specialist skills. And the difference is really just the salary level, because under the specialist stream, the salary level is minimum $140,000. Under the core skilled list, the minimum salary level is $76,500. Currently, what's going to happen on 1st of July, we don't know yet, but I'm sure there will be some increases to the salary levels just as much as our CPI, and hopefully not more than that. From a temporary visa 482, can a company offer permanent residency for their candidates or their employees, and that can be after 2 years or after 3 years or after 4 years. Depends what is the validity of the temporary visa. And as you know, a temporary 482 sponsored visa can be obtained for minimum 1 year, but up to 4 years. Sometimes employees would like to have the temporary visa for up to 3 years, because that gives a very comfortable period of time for the employer as well for the employee to transit over to permanent residency. There is a transitional permanent residency 186 which would be available. And just briefly, what is the 482, which, what the 482 visa stream really requires? And the main aspects is the valid standard business sponsorship, the nomination of the position. Sometimes our clients are asking, I have the sponsorship approved, how many people I can sponsor? Now you can sponsor a number of people, but each nomination would be a different nomination, and it has to be a new nomination. For the new nomination, of course, you must provide always a labor market testing. Only under a certain regime. So if your candidates are or prospective employees are from certain countries, you may don't require a labor market testing. We always recommend our clients to do labor market testing, even if it's not for 28 days, but at least for 2 years, because you can demonstrate that it's very difficult to seek and retain an employee from Australia, from the Australian workforce. So it means that you can demonstrate genuine need for an overseas candidate. But the absolute minimum is 28 days period, and the 28 days period have to be or has to be in the last 4 months before you would apply for the nomination. So this is one of the key aspects after receiving a standard business sponsorship. And once the position is nominated, then the visa application can be progressed to. Okay, so 3 distinct steps: sponsorship, nomination, and visa application. And just for the sponsorship, for some of the businesses who employed people in the past under the 482 stream, and they have over $4 million turnover, they may be eligible to seek an accredited sponsorship, which is very beneficial regarding the processing time, because if a company has an accredited sponsorship, processing time can be just a couple of days, sometimes maybe a couple of weeks, but definitely not 4 to 6 months as currently the processing time is. So this is in a nutshell what is required under the 482 stream. And as I mentioned, from that, there is a possibility to seek a permanent sponsorship or permanent nomination. And under the 186 permanent nomination, we have the 2 streams. One is the direct entry and one is the transitional. Direct entry sometimes beneficial for corporate employees like, CEO, CFO, if you would like to employ those candidates from overseas, they may require a direct 186 sponsorship nomination because they would like to have a security to come to Australia. This is our experience anyway with our high-level employees and candidates. The difference is for under the transitional stream, you would require only to demonstrate the 2-year employment with your nominating business and show and demonstrate that you have paid the relevant salary, what you have agreed to at the original 482 stream, and also the employee was carrying out the same work what they were employed for. That's a transitional. After 2 years, you can apply for that for the employee. The direct entry requires a visa applicant to have 3 years minimum experience in their nominated occupation and have a skills assessment. In addition to that, they must demonstrate English language ability, which is level 6 on each band in the IELTS stream. And it has to be in the last 3 years. Also, the skills assessment has to be valid when you apply or when you nominate the candidate, and that also cannot be more than 3 years old. So the difference is the transitional stream doesn't require skills assessment. So sometimes if your candidate doesn't have relevant qualification, but they have work experience which can substitute for formal qualification, then that would be maybe the only one way to offer them permanent pathway through the transitional stream. But if someone has the 3 years experience, skills assessment, English language ability, then that person can be sponsored for permanent residency. Now, permanent residency processing time at the moment is about 16 months. So really, if you have someone under the temporary stream for 3 years and you're happy to offer them permanent sponsorship or nomination, then it would be another 16 months. So altogether, probably a good 4.5 years what you can secure from an overseas candidate. Can be 10 years, can be 15 years. I sponsored myself overseas candidates in the past, and they are with me after 16 years. So it's really, what you're offering, how you can work together with an overseas candidate, and what is the performance. If your business is in a regional area, you can offer a candidate a so-called 494 visa, which is very similar to the initial 482 visa stream. But under this visa stream, the candidate must demonstrate 3 years work experience and must have a skills assessment. A very important aspect of this visa, if you have a candidate who applies for a job with you based on your advertising, and their visa may be refused previously and they are holding a bridging visa, they would not be able to apply for a 482 visa stream, but they are able to apply for a regional sponsorship onshore, okay? 482 can be always applied offshore and onshore, but if a person's visa was refused, so your candidate's visa was refused, then you only can apply onshore for a 494 stream. That's very important. The other big stream is under the labor agreement. You have not a sponsorship approval, but a labor agreement approval. And then you can, sponsor and nominate different candidates. Types of labor agreements, what we are talking today about, are company specific or industry specific. In an industry specific, we today talk about aged care labor agreements mainly, on higher labor agreements, and we touch base on the DAMA labor agreement as well. Next slide, please. Okay, so labor agreements, I'm sure you are all aware of this particular opportunity to use when you are an employer. And mainly the labor agreement is designed to address the skill shortage, and especially in certain regions, certain industries. And some of these labor agreements pre-approved in a sense by the Department of Home Affairs, because they have industry-specific labor agreement. What are the benefits of this? Flexibility when you cannot meet standard sponsorship, but not so much sponsorship, but more of a standard requirements, and that is you may have a unique position what is not listed anywhere in the migration legislation, then you can use the labor agreement under the company specific agreement. Next slide, please. Okay, this is just a listing, what type of labor agreements are available. We have the automotive industry, hospitality and tourism, and manufacturing, trades and construction, meat processing, aged care, on hire labor services, and nursing as well. But nursing and aged care is together, Next slide, please. Okay, so company-specific labor agreement, probably I would start with that because that's relevant to most of the businesses. So the company-specific labor agreement is available for occupations that are not on a skilled list, but it is minimum a skill level 4, which means that, we have a job description or position description list, which is under the Australian skilled occupation list called NSCO list, and that gives what type of skill level that occupation is. So, for example, if you would like to employ a commercial cleaner, that is skill level 4, that occupation is not on a skilled list, so you can use a labor agreement to employ commercial cleaners if that is your business. But all type of different occupations available, but it has to be up to skill level 4. Cannot be on a 482 stream. Cannot be, like facility manager, for example. Currently, on the specialist skilled list, but it's under the 482 stream. Salary level is minimum $140,000. So because this is on a specialist skilled list under the 482 stream, you would not be able to utilize the labor agreement to employ a facility manager. It is not on a core skilled list, but it's under the specialist skilled list and under the 482 stream. So therefore, you would not be able to use labor agreement for this particular occupation. The company-specific labor agreement is very much like a sponsorship application. The company must provide evidence of their financial ability, organizational structure, business profile, how the company sees the business is going to grow in the next few years, and how many employees they have. Now, extremely important that usually you can seek a labor agreement up to 25-30% of your Australian workforce. So what is that means? That if you have 30 employees, for example, then you would be able to get the labor agreement for up to 5 to 6 employees from overseas in this particular occupation. You would also require to do a labor market testing as you require for the 482 or the 186 stream. 186 stream is really just mainly for demonstrating the genuine need for the employee. But as under the 482, you require labor market testing. For labor agreement as well, you require the labor market testing. Also, under the company-specific agreement, you would require to have a communication with the Australian union, one of the union, the Australian Workers Union, for example, or if it's a construction industry, the CFMU, and we provide that services as a law firm. We contacting the union and seeking their approval. Or if they don't approve it, we still need to demonstrate to the Department of Home Affairs that we have been in communication with the union to seek this agreement. Once we have the communication and also industry endorsement, like, maybe your industry association can endorse that, this is a occupation that is in demand and they supporting your request for labor agreement. Or, another business which is working in the same space, they can provide an endorsement for this agreement. So the two very important things is getting a communication with the unions and also getting an endorsement that the position what you wish to have people from overseas that is in a great demand and you can't fill that position with Australian labor force. Once you have all this, then we can apply for the labor agreement. Unfortunately, it is a little bit taking some time. So the processing time is about 12 months, could be 16 months. So if you have forward thinking and you know that your business is growing and it's very difficult to get Australian employees, then you can think of having the company-specific labor agreement. As I said, this agreement is mainly for occupations that you cannot fill in Australia, and that is not available under the 482 stream. Industry-specific labor agreement, we have, for example, as I mentioned before, the hospitality industry, the meat industry, the fishery industry, the horticulture industry. That's all, pre-approved by the department, and the processing time is much faster. There are certain occupations under this agreement what you can apply for, but the whole process is very similar to the company-specific labor agreement. The other labor agreement is the designated area labor agreement, which is the DAMA. And in Queensland, we have the Cairns area and the Townsville area. South Australia, the whole South Australia is available for DAMA. Western Australia is available for DAMA. but New South Wales and Victoria has specific places which are available for DAMA sponsorship or DAMA agreements. And under the DAMA, under the designated area migration scheme, you would be able to obtain an endorsement from the local council or the local assessing authority. I mean, in Townsville, they call it Townsville Enterprise Facility, and they are the one who are approving the agreements. You have to seek an endorsement, very similar to a company-specific labor agreement, where you have to provide, your business proposal, why you would require international candidates, how many you require, and you have to provide a labor market testing, you have to provide organizational chart. But usually in these DAMA-specific agreements, the council or the local body who is approving this or endorsing these applications, they very much familiar with your business. I mean, usually I see that in Cairns, for example, that the assessing body, the chambers of commerce in Cairns, they know the business in a regional area and they know what the requirement is. The key aspect of the DAMA agreements, you don't require any union approval or communication with the union. And the agreement is going to be valid for 5 years, but all agreements is actually valid for 5 years. And in recent time, they changed the variation to the labor agreement to available only once a year. Okay, so why is that so important? Because when you initially apply for the labor agreement, you can list the occupations, the number of people, what concession you would require, because each labor agreement has their own concession. And the concession can be for the salary level, can be for English language level. You cannot say, okay, my candidate doesn't speak English and I still would like to employ, but you can have a reduced English language ability, which could be a 4.5 overall English. That depends on the area, under the DAMA stream, which area is the approving or endorsing body. But there is a concession for English language ability and also concession for age. And that is something very important as well under the labor agreements and under the company-specific, industry-specific, or the DAMA-specific, because the age concession is very important. Sometimes you find the best employee who are 47 years old, and they would not be able to transit over for permanent residency. So under these agreements, concession is available up to 55 years of age. So if your candidate turns 48 years old, they can do the temporary visa and then they can transit over to the permanent residency. These agreements available for the 482 stream and also available for the 494 stream, what we discussed before. It doesn't matter, it's a regional area because the DAMA is anyway in a regional area in each state. So the 494 would be an option. And again, under the endorsement, under the DAMA agreements, the visa applicant must demonstrate 3 years experience and skills assessment. For a 482, there is the requirement, the work experience and minimum English language level 5 for the 482 stream. Same requirements under the DAMA approval. But as I said, the English language can have concession, the salary can have 10% concession, and the age can have a concession up to 55 years of age. So these agreements are very, very important for businesses where they find, certain employees from certain countries and with certain age, and they would like to employ them. Okay, next slide, please. Now, I believe, just give me 1 second, please. Yeah. We have now the aged care industry labor agreement, which is very specific, and it has been designed to assist growing needs for taking care of our aged population, and local recruitment sometimes not available because in an area where you cannot find Australian employees, and also who can use this agreement, approved residential aged care providers, or not NDIS providers, but aged care approved businesses, and it has to be government approved, all right? Providers that delivering government funded aged care, these are the main areas where you can use the aged care labor agreement. Benefits of having these agreements: the reduced English language requirements. I mean, you still would like to have certain English language ability because, your employees required to communicate with your clients or customers. And the 1 year work experience is sufficient under this agreement, and pathway to permanent residency. These are the benefits, which could be attractive to you as an employer and also attractive to the employees as well. Occupations available: aged or disabled carer, nursing support worker, and personal care assistants. These are the occupation under the labor agreement. Now, thank you. Yeah, just go to the next slide, please. Yes. What makes it different from other agreements? There is specific occupations, what's on the list: English language requirements, concession, skills and qualifications. So if a person doesn't have a qualification but have 1 year work experience, then they can apply. Age limit, as I mentioned before, for permanent residency can be 55 years of age. Now, I have a couple of additional information where I would like to just list, those bodies, because under this agreement you also require an MOU, which is a memorandum of understanding from different unions, and these unions or associations could be the Australian Nursing and Midwifery Federation, the Health Services Union, HSU, and the United Workers Union, the UWU. These are the unions which are able to approve the MOU, the Memorandum of Understanding, or signing off on a Memorandum of Understanding, which is required to lodge the labor agreement. Once you have this Memorandum of Understanding, then your labor agreement can be processed very quickly. Our experience is usually 4 months, roughly 3 months. Also depends if you have previously used any labor agreement which was approved by the unions or the associations. It's, as I said, very quick, and you can seek a number of positions and a number of candidates. You might want 10 aged care, and disabled carers position. Depends again how many Australian employees you have. So that's in a nutshell about the aged care labor agreement. So the key is, and also one more very important information, that the salary level is around $51,000-$52,000, which is prescribed by this industry-specific agreement, okay? So not $76,000, which is the normal 482 visa stream salary level. So between 51,222, but just between $51,000 and $52,000. This is what is the salary level. Next slide, please. Okay, we have another very important labor agreement as well, which is the on-hire labor agreement. And under the on-hire labor agreement, businesses who have recruitment businesses and they hiring out staff, they can utilize this agreement. And the key aspect of this is that recently the department has introduced a new salary level, which is 20% above the general minimum salary level. So if a minimum salary level is $76,500, the salary what you as a labor hire company you must offer is extra 20%. So it would be an extra $17,000. So it would be around $90,000 to $93,000 what is required as a salary to be paid under the on-hire labor agreement. So all the other requirements are the same, except that under the on-hire labor agreement, you only can employ people who are under the temporary stream. So you cannot employ people where the occupation is not on the temporary skilled list. So not under the core skilled list and not under the specialist skilled list. So say, you would like to employ a motor mechanic, that's available under the core skilled list. So you can hire this person out, but the salary has to be minimum, 20% extra above the basic salary level. The on-hire labor agreement it requires the same evidence as the company-specific labor agreement, except we won't require union approval or union communication. So that's something which is, distinctive from the company-specific labor agreement. So just to summarize that, the occupation must be on a temporary skilled list, okay? Can be core and can be specialist skill. The salary must be minimum 20% above the TISMIT. That just recently, last year, has been introduced. And if you don't require the union approval for the on-hire labor agreement. I think that's very important, as these are the distinction amongst the other labor agreement, the company-specific labor agreement, or the industry-specific aged care labor agreement. Next slide, please. Okay, so key benefits of labor agreement for employers, okay, secure long-term employment, as businesses, we are all aiming to have our employees and, overseas or Australian employees to be with us for a long time. Access to dedicated skilled labor force, flexible workforce mobility, cost-effective hiring, and build a reliable global talent pipeline. Now, some occupation is very, I understand and I know from experience that some of the occupations are very, very difficult to fill with Australian labor force, and these agreements or the whole sponsored and nominated regime can be utilized by employers and businesses to recruit, secure, and retain employees for a long term. Next slide, please. Employer eligibility, who can request labor agreement? I have mentioned that before. You must be, a registered business in Australia. That's an overall view. So you must be a registered business in Australia. So ABN, ACN number. You must demonstrate that you are financially viable and you can pay the employee's salary. That's one of the key aspects. Compliance with workplace law, like sometimes you may have previous breach of work and compliance rules. It doesn't mean that you cannot use these streams and these facilities, but it just has to be, explained what happened and what was the outcome of any investigation, if it's applicable, certainly. Financial capacity, as I mentioned before, what is the industry significance and long-term workforce strategy. You might have, a 3 year plan. I'm working with a big company where they have a cyclical work and they have to think ahead for 18 months, for 3 years, what's going to happen. So they securing and recruiting candidates according to that. So that's very important. Employers can also strengthen their long-term workforce strategy by supporting local graduates through the professional year program for international graduates. That's a particular visa class, okay? And that's available, if you're working with universities, especially in local areas, that they have. I think that's usually available for engineers or some specific occupations. And you can have this graduate stream and you can offer that to the employees or graduates. Next slide, please. Oh, that's something also very important, and that's across the board, under the 482 stream, the 186 stream, labor agreement stream. That's all very important because it has to, be compliant with the Department of Home Affairs. There are some obligations what prescribed by the Department of Home Affairs, which you have paid the salary what you have promised to the employee. You have asked the employee to do the work what you initially asked them to do. So you cannot just you have an overseas candidate and now there is another occupation becomes available. You cannot just transfer the overseas candidate to another occupation during the life of their visa. You can, but you need to seek a variation to the nomination, and it has to be a new nomination which has to be approved. So very important. Salary level, same position, what they do, meeting Australian fair work requirements, holiday, sick leave, superannuation. This is all has to be paid and be compliant with. The key aspect of the sponsorship, and that's usually coming up when we're talking to our clients, what it is if it doesn't work out and the employer leaves us, where does that leaves us, and what is our requirement. The only one requirement is when you're employing overseas employees to meet Australian industrial law requirements. And if for some reason the employee is not working out and you have to terminate their employment, you must notify the Department of Home Affairs within 7 working days about the termination and just send a notification, this is what happened and we terminated the employment. If the employee must return to their home country because they cannot find another employer, then as a sponsoring or nominating company or business, you are required to pay a one-way airfare back to their home country. It's called repatriation expense, and that's a one-way ticket back to their home country. Also, I think it's important to mention here that if the employee has a family member and they including the family members in the process, then the employer must provide a statement that they extending the sponsorship to the family member. No position or salary or employment is required. It's simply a statement where you're accepting that the main visa applicant or the main visa holder has a family member and you are aware of that. And that's relevant to children or to the wife or the husband, of the visa applicant. Monitoring can happen by the Department of Home Affairs, and you must avail yourself to provide the evidence regarding those requirements. Okay, so if they come in and they say, can you please provide us this? Can you please provide us that? Yeah, you must provide those information to the Department of Home Affairs. In some instances, they can suspend the sponsorship, so they can make certain sanctions, they can cancel the sponsorship. So it's very important that you keep everything in line with the original promise, like, the contract what you have signed with the employee, but it's just like the same as with any Australian employees. Next slide, please. Very important that when you do, sponsorship, nomination, and visa application, that you seek expert advice and you know how to do labor market testing, what salary you would require to pay, what is required for work experience, for qualification, certain licensed occupation requires specific skills assessment, many intricate requirements, for these applications, which can be tedious, and I would strongly recommend to use a expert like No Borders Migration or NB Migration. And sometimes it's very beneficial to get in contact with an employment lawyer or industry expert, because you might have to do certain employment contract, which can extend to certain industry specific requirements, like as hospitality industry requirements. Do you have to pay overtime, when you require to pay, how much you have to pay? So I think this is all very important, and I would strongly recommend to seek, this legal support when you're applying for the visas and for the nomination and for the sponsorship. That is, I believe, from me. All right. So you can take a snapshot of the QR code, what we had before. And if you require any assistance, I am certainly here to support you. And if you have any question right now, I am happy to answer that. Thank you, EJ.
Thank you, Agnes.
Yes.
I think we have one question.
Yes.
For those who have questions, feel free to send them in the message box or the Q&A segment.
Let me just see
So,
previous question. Can you read that to me, because I
yes,
lost it?
no worries, Agnes. So the question is from Nina West. My employee based in overseas is
Mhm,
employed as part-time for more than 1 year, but
mhm.
she works 40 hours per week. Is it possible to count her hours as full-time work experience?
So is she already been sponsored, or she's on a sponsored visa, or she just employed previously by another employer?
Mm.
If you have been employed previously part-time and you need to demonstrate full-time experience, or okay, other employer, fine. If you would like to use your part-time employment of 40 hours, that is allowed. Casual employment also allowed to be used, but you must demonstrate that you worked minimum 38 hours. Have I answered your question? Excellent, thank you. Other questions?
I believe that's the only question we have so far, Agnes.
If you have no further questions, okay, Joanna, yes. Thank you, Joanna. Thank you. All right, EJ, I think I might gonna say bye to everybody, and thank you for attending, and hope I have given some additional information what you maybe already knew, or new information what you were not aware of. Have a wonderful day. Thank you. Bye, everybody.